Hi everyone, my name is Vardhan Chaturvedi and I'm an legal intern at LEXIS and Company. So today we are going to talk about infringement. So infringement is if use of an exclusive right of the owner without his consent or without license, then it will be considered as infringement provided it does not fall under section 52. Infringement can be broadly classified into two. First is primary infringement, second is secondary infringement. Primary infringement deals with the real act of copying, while the secondary infringement deals with other kinds of dealing, like selling the pirated books and importing. Section 51 is copyright is deemed to be infringed. Any person without the license or in contravention of the license does anything exclusive right of which rests with owner, permits for profit any place to be used for communication of work to public where such communication is infringement unless no reasonable ground to be believed that is infringement. Uh, when any person sale, hire, displays for sale or infringing copy or distributes any infringing copies of work. Import of one copy of work for domestic use is not an infringement. Plea of common source. In the case of Shyamlal versus Gaya Prasad, some principles were stated below as a compilation may be derived from the common source falls within literary work. A work of compilation of a nature similar to other will not by itself constitute an infringement. It is a question of fact to be determined from circumstances of each is. Infringement by copying. Copy is that which comes so near to the original as to give every person seeing it the idea created by original. Any resemblance between the plaintiff work and the defendant work would not necessarily imply an instance of infringement of the plaintiff work, although it may play a role in proving infringement. The copying requirement protects that defendant who has never consulted the plaintiff's work nor has access to it but works in because of the coincidence or artistic convention substantially similar to that of plaintiff. Recognizing that direct evidence of copying will be rarely available, court has universally allowed copyright owners to prove copying on the basis of circumstantial evidence, especially through inferences from defendant's access to the plaintiff's work and from many similarities between two works. Copying can therefore be proved by inference. It can be inferred that the defendant has in fact copied the plaintiff's work from the fact that the defendant had access to the plaintiff's work and from similarities between his work and that of plaintiff. So direct copying, the conclusion depends upon the effect produced in the mind of the person. Substantial copying is like striking similarity. In the case of Ladbroke versus William Hill, depends upon the quality than the quantity of the work. The facts of the case were William Hill's fixed odd football coupons, a sheet of paper in which list of forthcoming matches were printed. William Hill had been using these coupons since the early 1950s, and when Ladbroke had decided to enter the field, it adopted a similar product. Indirect copying. Novel turned into play, which is again turned into ballet. To see the substance, the foundation, the test as to whether the reproduction was substantial was to see if the rest could stand without it. If it could not, then ever it dissimilarities are there in the infringement. Infringement by permission to use play for communication of the work. Secondary acts. Permitted the use of work for profit. Infringement also occur when any person distributes infringing copies for trade or not for trade, sells or let for hire, and displays for offers for sale. In the case of Ryoti Saran versus Numero Uno International, plaintiff write dialogues from defendant for his TV serial. This was a landmark case, The Great Marathas. A consolidated fee of 20,000 per episode was fixed. The defendant failed to make payment for some episodes. Plaintiff said infringement of episodes whose payment has not been made. Remedy to plaintiff is enforcement under general contract law and not copyright law.